After 27 years securing their patents, the CEO said I lacked startup energy and replaced me. Need a visitor pass? The young security guard asked. I'm David Chen, Chief Patent Officer. He checked his tablet. You're not in the system. Then came the voice I least wanted to hear. David. Marcus Brennan, our slick CEO, approached, smiling like always. Perfect timing, let's talk. Inside the conference room, HR was already waiting. David, Marcus said, you've been invaluable, but we're pivoting. Faster cycle, times, less legal drag. I stared. I've protected over 300 patents, I said. Our IP portfolio is valuable, yes, but slow. We need to ship, iterate, and fail faster. HR slid a folder across the table. Severance, 6 months, full benefits. A glowing exit. This isn't personal, Marcus said, already walking out. It's evolution. I sat alone, staring at a dollar amount meant to erase 27 years. The house felt different when I walked in at 2 p.m. on a Tuesday. Sarah, Sarah, not the HR Sarah, looked up from her laptop, confusion flickering across her face. You're home early, she said, then saw my expression. Oh, honey. What happened? I sat down heavily at our kitchen table, the same table where I'd reviewed countless patent applications over family dinners, where I'd missed birthday celebrations because of filing deadlines, where I'd explained to my teenage daughter why Daddy couldn't come to her recital because of a critical prior art search. They let me go, I said simply. Sarah closed her laptop and moved to the chair beside me. After 32 years of marriage, she knew when to ask questions and when to just listen. Marcus said I lacked startup energy, said legal review was slowing them down. She took my hand. David, you built their entire IP portfolio from nothing. Remember when you started there? They had 3 employees in a garage. I did remember, fresh out of Stanford Law, eager to prove myself in Silicon Valley's Wild West. TechFlow was my first real job, a scrappy little company with big dreams and bigger ambitions. I'd worked 18-hour days crafting their first patent applications, by hand, learning the intricate dance between innovation and protection. The early days had been exhilarating. Every patent approval felt like a victory against established giants. I'd built relationships with patent examiners, learned the quirks of different technology classifications, became fluent in the peculiar language of claims and specifications. As TechFlow grew, so did my responsibilities. I hired junior attorneys, built processes, created the legal infrastructure that allowed rapid scaling while maintaining bulletproof IP protection. My department became known throughout the industry. Headhunters called regularly, offering lucrative positions at major firms. But I stayed. Through IPO stress and acquisition rumors, through leadership changes and strategic pivots. I stayed because TechFlow was my baby too. Every patent in our portfolio bore my fingerprints. Remember the Morrison case? Sarah asked quietly. How could I forget? 5 years ago, a competitor had tried to invalidate our core networking patents through an inter partes review. The legal bills had exceeded $2 million, but we'd won decisively. The technology that now generated 60% of TechFlow's revenue remained protected because of that victory. Marcus had thanked me, personally then. David, you just saved our company, he'd said. We couldn't do this without you. We'll move faster without legal friction. I thought about the late nights I'd spent reviewing license agreements, the weekends lost to prior art searches, the family, vacations interrupted by urgent cease and desist letters, all friction apparently. What will you do now? Sarah asked. I looked out the window at our neighbor's pristine lawn, their Tesla charging in the driveway. Successful people in successful careers, building successful futures. I don't know, I admitted. But even as I said it, something crystalline was forming in my mind. A pattern recognition system honed by decades of patent prosecution was beginning to identify opportunities in the landscape of my betrayal. The coffee shop on University Avenue buzzed with the familiar energy of startup dreams and venture capital pitches. I'd chosen a corner table where I could observe without being observed, a skill learned from countless depositions and negotiations. My laptop screen showed TechFlow's latest product announcement. Marcus grinned from the stage at Tech World Conference, gesturing enthusiastically at slides showcasing their revolutionary new AI-powered networking protocols. Revolutionary. The word tasted bitter. I'd written the original patent applications for those protocols in 2018. Every technical detail, every algorithmic innovation, every potential claim scope. I knew them like my own fingerprints. David Chen? I looked up to find Jennifer Walsh, a former colleague from Morrison Forster, who now ran IP strategy for a major law firm. Professional smile, expensive suit, the kind of confidence that comes from billing $800 an hour. Jen. I stood to shake her hand. Good to see you. I heard about TechFlow, she said, settling into the opposite chair without invitation. Industry gossip travels fast. I'm sorry. These things happen. She studied me with litigation attorney intensity. Actually, that's why I'm here. We're representing several clients in patent disputes with TechFlow. Your departure has created opportunities. I sipped my coffee, keeping my expression neutral. I'm not interested in working against my former employer. Of course not, but consultation work, expert witness testimony? You know their IP portfolio better than anyone alive. She leaned forward. The Morrison case alone establishes your credibility. You could name your rate. After she left, I sat quietly, watching the startup ecosystem swirl around me. Young entrepreneurs, pitched to graying investors, everyone convinced they were building the next unicorn. Most would fail. Some would pivot. A few would succeed spectacularly. But they all shared one fundamental misunderstanding. They thought legal protection was optional, a luxury for later stages of growth. They prioritized speed over security, momentum over moats. Marcus was making the same mistake. That evening, I opened a new document on my home computer. Not a patent application this time, something more comprehensive. I began mapping TechFlow's entire intellectual property ecosystem, every patent family, every licensing agreement, every potential vulnerability. The filing system I'd built over 27 years contained meticulous records. Prior art databases, examiner correspondence, prosecution histories, international filing strategies. I'd been thorough, perhaps obsessively so. Now that thoroughness would serve a different purpose. I spent the next 3 weeks conducting what I privately called landscape analysis. Public records, patent databases, international filing systems. All perfectly legal research, the kind any competent attorney might perform for due diligence. Patterns emerged. TechFlow's patent protection, so robust in established markets, showed curious gaps in emerging territories. Certain key innovations lacked international coverage. Some applications had been filed with incomplete technical specifications, corner-cutting that would have horrified me 5 years ago, but apparently represented acceptable risk in the new move-fast paradigm. Most interesting were the provisional applications filed in the past 18 months. Without my oversight, the technical descriptions had become sloppy. Broad concepts, without enabling detail. Claims that wouldn't survive serious prior art challenges, legal friction eliminated just as Marcus wanted. I made careful notes, building comprehensive maps of vulnerability. Not for revenge, not yet, but for understanding. Knowledge has always been my weapon of choice. The email arrived on a Thursday morning, forwarded from my old Stanford classmate who now worked for the Patent Trial and Appeal Board. Subject line: Thought you'd find this interesting. It was a notice of inter partes review petition filed against 3 of TechFlow's core networking patents. The petitioner was listed as Optimal Systems LACKED, a company I'd never heard of, registered in Delaware with an address that traced to a corporate services firm, but I recognized the legal arguments. Sophisticated, precise, devastating. Someone had done their homework. I called my friend at the PTAB. Mike, that IPR petition you forwarded? Any idea who's behind Optimal Systems? Off the record? No clue. Shell company, definitely. But whoever drafted this knows their stuff. The prior art analysis is surgical. They're targeting the exact claims that matter most. After hanging up, I sat staring at the petition document. The prior art references were obscure but absolutely on point. Japanese patents from the 1990s, European applications that never proceeded, to grant academic papers from conferences most practitioners wouldn't even know existed. This wasn't random. This was someone who understood patent prosecution at the deepest level. My phone buzzed. Text message from an unknown number. Noticed. The IPR filing. Impressive work. Coffee tomorrow? A friend, I almost deleted it. Then curiosity won. The next morning I found myself at a different coffee shop. This one in Menlo Park, far from the startup crowds. A woman in her 40s sat at a corner table, laptop open. Completely unremarkable except for her eyes. Sharp, calculating, familiar with complex strategy. Dr. Chen? She stood as I approached. Monica Reeves. I represent certain interested parties. Interested in what? TechFlow's cavalier approach to She gestured to the chair across from her. Your former employer has made some very public statements about moving fast and breaking things, including apparently proper patent prosecution procedures. I remained standing. I'm not interested in corporate espionage. Nothing illegal. Everything we're discussing exists in public records. She opened her laptop, showing me a database I recognized. The patent prosecution history search tool I'd helped design years ago. Your replacement, Ms. Jennifer Kim, seems to have a different philosophy about claim scope and enablement requirements. The screen showed recent TechFlow applications. Even from across the table I could see the problems. Overbroad claims, insufficient technical detail, prior art citations that missed obvious references. Someone's going to challenge these eventually, Monica continued. Better to control the timing and methodology. Better for whom? She smiled. For justice, for proper respect of intellectual property law, for ensuring that companies can't simply ignore legal requirements because they're inconvenient. I sat down. Over the next hour, Monica outlined what she called a comprehensive patent landscape analysis. Multiple IPR petitions targeting TechFlow's weakest patents, prior art submissions on pending applications, strategic licensing discussions with key competitors. The beauty, she explained, is that it's all perfectly legal. We're simply exercising existing procedural rights within the patent system, rights that exist specifically to prevent the kind of corner-cutting your former employer now embraces. What's your role in this? Coordination. There are several parties interested in ensuring TechFlow's patents receive appropriate scrutiny. Technology companies who feel threatened by aggressive licensing tactics, academic institutions concerned about improper claim scope, public interest groups focused on patent quality. She slid a business card across the table. Think about it. You spent 27 years building an ironclad patent portfolio. It would be a shame to see it degraded by inexperience and haste. That evening I researched Monica Reeves, corporate attorney, former USPTO examiner, specialist in patent validity challenges. Her clients included several major technology companies, including 2 that competed directly with TechFlow in the networking space. The next morning brought another forwarded email from Mike at the PTAB. 2 more IPR petitions against TechFlow patents. Different petitioners, same surgical precision in the prior art analysis. Marcus's response appeared in TechCrunch that afternoon. Patent trolls are attacking innovative companies with frivolous challenges. This is exactly why we need patent reform to protect real innovation from legal harassment. Patent trolls. The irony was exquisite. I'd spent years helping TechFlow defend against actual trolls. Shell companies that existed solely to extract licensing fees from legitimate businesses. These challenges were different. Targeted, substantive, technically sophisticated, someone was systematically deconstructing the patent portfolio I'd spent decades building. My phone buzzed. Monica again. Saw the TechCrunch article. Interesting response strategy. Coffee Monday? Found myself typing, yes. The Bloomberg headline appeared at 9:47 a.m. on a Tuesday. TechFlow's patent portfolio under federal review after SEC whistleblower complaint. I read the article 3 times before the implications fully registered. Someone had filed a detailed complaint with the Securities and Exchange Commission, alleging that TechFlow had materially misrepresented the strength of its intellectual property portfolio in recent investor communications. The whistleblower, identified only as a former senior employee with extensive knowledge of the company's IP strategy, had provided the SEC with comprehensive documentation showing systematic weaknesses in patent protection that directly contradicted statements made to investors and analysts. My phone started ringing immediately. David, did you see the Bloomberg piece? Marcus's voice carried a strain I'd never heard before. We need to talk. This is a disaster. I'm no longer employed by TechFlow, I reminded him calmly. The SEC is asking for expert analysis of our patent portfolio. They want to understand the gap between our public statements and actual protection scope. His words came faster now, panic bleeding through professional composure. You know our IP better than anyone. We need your help. You said you'd move faster without legal friction. David, please. Whatever this costs. I hung up. The next call came from Jennifer Kim, my replacement. Dr. Chen, I'm in over my head here. The SEC investigators are asking technical questions about prosecution strategy going back 15 years. I don't understand half the references in these patent files. I'm sure you'll figure it out. You have startup energy. The third call was from TechFlow's outside counsel at Wilson Sonsini. David, we're dealing with a coordinated attack here. 7 IPR petitions, an SEC investigation, and now 3 major customers are asking questions about IP indemnification clauses in their licensing agreements. I listened without comment as he outlined the scope of the crisis. The patent challenges were succeeding. 3 key patents had already been invalidated, with more decisions pending. The SEC investigation was expanding to include potential securities fraud charges. Major institutional investors were demanding emergency board meetings. The company stock is down 30% in 2 days, he continued. At this rate, we're looking at complete collapse within weeks. That afternoon, I drove past TechFlow's headquarters. News vans lined the street. Through the glass facade, I could see clusters of employees gathered around monitors, watching their stock options evaporate in real time. Marcus appeared on CNBC at 4 p.m. looking haggard despite professional makeup. These attacks are coordinated and baseless, he insisted. TechFlow has always maintained the highest standards of intellectual property protection. The interviewer pressed him on specific patents mentioned in the SEC filing. Marcus fumbled, the technical details referring repeatedly to our legal team's assessment and industry standard practices. But your former chief patent officer had a different assessment, the interviewer noted. According to our sources, Dr. David Chen raised concerns about patent quality before his departure. Marcus's expression tightened. Dr. Chen was philosophically aligned with older approaches to IP strategy. We needed to adapt to modern market realities. Modern market realities that apparently included filing patents that couldn't withstand basic validity challenges? The interview ended early. By Friday, 3 more major investors had filed securities fraud lawsuits. TechFlow's market capitalization had fallen by 60%. The networking division, built on patents I'd prosecuted personally, was hemorrhaging customers as competitors questioned the company's ability to maintain IP protection. Monica texted me that evening. Impressive week. Coffee tomorrow? I didn't reply, but I couldn't help smiling. 6 months later, I stood in the conference room of Patterson & Associates, the boutique IP firm where I'd accepted a senior partner position. Through the windows, I could see the construction crews working on TechFlow's former headquarters building. New ownership, new logo, new purpose. The company had imploded exactly as predicted. Marcus resigned in disgrace, accepting a settlement that included admission of securities violations. The patent portfolio, what remained of it, had been sold to a consortium of technology companies for 30 cents on the dollar. Most employees found positions elsewhere, though many still struggled with the reputation damage. Jennifer Kim had called me twice in the past month seeking career advice. I'd politely declined to help. Some lessons can only be learned through direct experience. David? My new partner, Ellen Patterson, knocked on the doorframe. The Jung Industries team is here for the portfolio review. I gathered my files and walked to our main conference room. 8 executives from the Chinese technology conglomerate sat around the polished table, led by CEO Dr. Amanda Zheng herself. Dr. Chen, she said, standing to shake my hand. Thank you for taking this engagement. We need someone with your expertise to evaluate certain acquisition opportunities. I took my seat at the head of the table. My understanding is that you're interested in networking technology companies with strong patent positions. Exactly. We've identified several targets, but we need thorough IP due diligence before proceeding. She opened a leather portfolio. Our primary concern is ensuring that target companies have actually secured meaningful patent protection, not just filed applications with inadequate technical specifications. One of her subordinates placed a stack of documents on the table, patent portfolios from 6 different networking companies, each tabbed and organized for systematic review. I recognized several of the companies, TechFlow competitors that had survived the recent market upheaval precisely because they'd maintained proper intellectual property practices, companies that understood the difference between speed and recklessness. We're particularly interested in this portfolio, Dr. Zheng continued, indicating a company called Next Gen Networks. They've developed some interesting routing protocols that could complement our Asian market strategy. I opened the Next Gen file and immediately saw quality work, careful claim construction, comprehensive prior art analysis, proper international filing strategies. The kind of prosecution I'd built. my reputation on. This is solid work, I told her. Whoever handled their IP strategy understood both the technology and the legal landscape. You'd be getting genuine protection, not just paper patents. Dr. Jung smiled. Excellent. We'd like to retain your firm for the full acquisition analysis. Due diligence, valuation, prosecution support, everything. After they left, I returned to my office and opened my laptop. The afternoon sun streamed through windows that faced west, toward Silicon Valley's endless cycle of creation and destruction. My phone showed 3 new messages, 2 from former TechFlow employees seeking recommendations, 1 from a journalist, working on a retrospective article about corporate IP strategy. I deleted all 3 without reading them completely. Instead, I opened a new document and began drafting patent claims for a client's quantum computing innovation. Precise language, careful scope, thorough technical enablement. The kind of meticulous work that builds lasting competitive advantages. Legal friction, Marcus had called it. I preferred to think of it as craftsmanship. Outside my window, the sun set over a valley where startups rose and fell like digital wildflowers, each convinced they could bypass the fundamental rules of intellectual property protection. Some would learn those rules the easy way, through proper counsel and careful strategy. Others would learn them the hard way, through invalidated patents and securities investigations. I was no longer particularly concerned about which path they chose. After 27 years of building other people's dreams, I was finally building my own. And this time, I controlled all the intellectual property.